call the member for Balmain.
Thank you very much, Mr Deputy Speaker. I rise to speak on the non-profit bodies Freedom to Advocate Bill 2015, and I commend the member for Liverpool for proposing this legislation. It's an important debate that we're having here today in the House. I understand from the Minister's contribution this morning the government will not be supporting this bill. And I think that's a great shame, Mr Deputy Speaker. It's a shame because this bill provides for the opportunity for non-profit bodies in this state to be unfettered, to be free from the restrictions that government places on not-for-profit organisations in order for them to receive the crumbs from the table of government when it comes to providing them with the revenue that they need to support people in our community, often the most vulnerable, and often those people who are forgotten in places like this Parliament. This bill seeks to prohibit the State of New South Wales entering into agreements with non-profit bodies that restrict or prevent those bodies from engaging politically and campaigning on issues of state law, policy and practice. Well, the Minister tells us really it's unnecessary, that these NGOs can do some advocacy, they can speak out, and it's not really something that's required. But I think all of us, Mr Deputy Speaker, have been in a situation where community organisations in our electorate have spoken with us, where they've talked in the community amongst themselves and amongst the organisations that exist in our own electorates, and there is no doubt in my own experience that I have seen the concern, the fear, that unless there is some explicit legislation which protects people's rights to be able to advocate and in fact sets it out in a clear and specific way, that their advocacy is fettered, their voice is fettered. And I'll give you the example which I'm sure the Minister will know a lot about, which is the going home, staying home reforms, which was, I think we can all admit now, a shambles, which was ineffectively implemented and which was a major headache for the government, but also, of course, a major headache for women's refuges and other organisations in the community. And it was the not-for-profit sector, the NGOs in that sector, that worked constructively and closely with the government to get a positive result. And the Minister might say, well, that means this legislation is unnecessary. But we know, and I know myself in meetings that I attended, where not-for-profit organisations, where NGOs felt that they weren't able to speak out. Oh, we don't want to get on the wrong side of the government. We don't want to be having arguments with them. We don't want them to be thinking that we're being political. We're not political. We're just trying to speak out on behalf of people in our community. Well, this legislation solves that problem. This legislation gives organisations the confidence in a legislative framework to know that they can speak out and advocate on behalf of their community. And it's protected. The power that sits in the Minister's office, the authority of the Minister, the often invisible authority of the Minister won't be imposed on these organisations because we, the Parliament, will protect them against that power that the Minister wields. We, the Parliament, will give the right to those not-for-profit organisations to be able to stand strong and tall, representing those people in the community who often don't have a voice. Organisations like the Redfern Legal Centre, that do a lot of important work around police oversight, the Environmental Defender's Office, that works around particularly charged environmental issues, we can see a lot of the cases that these organisations put forward are often ones that are controversial, where there's often pressure from media and also from ministers for them to be quiet, for them to stop meddling in what they see as the minister's business. But what we have the opportunity to do here today, as a Parliament, is to say that you have that right to speak out freely. Not an implied right, which is subject to the authority, the pressure, the intimidation sometimes from media or from the Minister's office, but we give you that right to speak freely. If this isn't about classic liberalism, I don't know what is. If this isn't about us protecting the rights of organisations, if this isn't about protecting the rights of individuals and organisations to speak out in favour of other people, that right to freedom of speech, I don't know what is, Mr Deputy Speaker, because what we heard today from the Minister is saying that, don't worry, everything's all right, things will continue as usual. But what we know is there is a sense of fear, there is a sense of concern, and a lot of organisations feel they are unable to speak out in the face of the authority of the Minister in particular. We've seen federally, of course, that the federal Abbott government has reduced funding for a range of peak bodies, peak organisations, as the federal government has cut through many advocacy organisations, cut down their funding in an attempt to silence them, to make sure that their voices aren't strong in our civil society. And that's why this bill is even more important, because this bill gives rights to organisations, explicitly sets out that they are able to advocate on behalf of those people who are often most vulnerable in our society. And what we know when we stand back is the importance of a democracy is not just the parliament, it's not just the judiciary, but it's civil society. We need to build robust, strong civil societies. We need to have a level of depth and breadth in civil society organisations to act as a bulwark against authoritarian government. If government doesn't seek to do the things that the community might support, that they should feel free to advocate. Why should they advocate? Well, why should we pay for it? Why should we pay for it? We're not saying the taxpayer should pay for it. If you've read the bill, you'll actually know what we're talking about. And the member there underlies his lack of understanding. This is not a bill which is saying, let's give NGOs money to be advocates. But what it's saying is, these organisations that work in these areas, we need to have a framework which allows them to be able to put their view. That's simply what it says. And if it exists already, what's wrong with codifying it? What's wrong with codifying it? Because we know that the authority of the minister, whether it be this government or another government, is very strong. And it is no harm. It is no harm. It is no harm to ensure that we can give those people the right. And let me talk through this detail for them, because in May 2013, the O'Farrell government issued a new legal assistance services funding principles that put limits on the activities of 40 community legal centres and 22 legal aid offices. The Environmental Defenders Office in particular has played a crucial role in allowing members of concerned communities across the state to stand up against inappropriate developments, even where such developments were sanctioned or proposed by the state of New South Wales. The funding principles prohibit, quote, lobbying governments and elected officials on law reform and policy issues and, quote, public campaigning and advocacy, including the use of traditional social media, participation in rallies or demonstrations for causes seeking changes to government policies or laws. If that is not silencing their perspective. So what this means, if you've been in the EDO, you go to court, a court matter is resolved in your favour, and you say, the government should change the law to fix this. That's prohibited. You're not allowed to say that, even though it's been demonstrated there may be a problem or concern or a contradictory situation which has been outlined by the court. You can't advocate that to government. You can't say to government, you need to change that. The courts have determined there's a problem here because you're forbidden from doing that. The cruelling of these organisations, is a major problem. And we hear the other side say, well, you can as an individual approach your local member. Well, but these organisations that have got the experience and skills should be able to put that case to government. They should be able to say, this is our experience and this is something that we think should be protected. The linking of funding to silence on behalf of these NGOs comes at a time when governments around Australia and the world are doing what they can, often to marginalise dissent and dissenting voices. It's our view that the democracy should be made up of a broad range of voices and organisations should have the maximum opportunity of freedom of expression. But the Conservatives on this side believe that freedom of expression should be cruelled and should not be able to be promoted. There's a wealth of understanding of grassroots experience in these local organisations, and they can actually add something to government. We welcome the not-for-profit sector. We welcome them to make contributions to government. They sometimes oppose the position that we Greens put forward, but we welcome the contribution from other sides, and we think that's important. It should not be a matter for an organisation to have to weigh up its own future funding requirements before, for instance, making a submission to a parliamentary inquiry. If a group wants to make a submission or to advocate, we believe that is important. We believe in a democracy with robust debate. We believe in a democracy with freedom of speech. We believe in a democracy that is robust, that ensures that civil society can make a strong contribution. Mr Deputy Speaker, We support this ideal of a robust civil society and believe that we should be allowing the maximum amount of freedom of speech for these organisations without having to weigh up whether they be funded before they can even make something as simple as a submission to a parliamentary inquiry.